Some stories stay with you not because they are extraordinary, but because they are true in a way that cuts through everything. True in the way that makes you go quiet for a moment. True in the way that makes you think about every institution you've ever trusted, every authority figure you were told to respect without question, every young person who ever sat in a chair across from someone powerful and had absolutely no idea they were being harmed. I've spent years looking at cases that happen inside institutions, schools, hospitals, government offices, places where the relationship between the powerful and the vulnerable is built into the very structure of the room. And what I've learned, after all of that time, is this. The most dangerous abuses are not the dramatic ones. They are the quiet ones. The ones that happen in offices with closed doors. The ones that get dressed up in the language of discipline and procedure and the good of the community. The ones where the person doing harm has convinced themselves, and often everyone around them, that what they are doing is not only acceptable, but necessary. What happened to a 17-year-old named Isaiah Torres inside Crestfield Academy is one of those stories. And the way it ended, in a courtroom, in front of a judge who understood exactly what she was looking at, is the kind of ending that shouldn't be rare. But it is, which is exactly why it matters. Crestfield Academy was the kind of school that led with its reputation. A private preparatory institution in a mid-sized city, the sort of place with a long driveway, a crest above the entrance, and a history of sending students to universities that other schools put on posters. Parents paid significant tuition for the Crestfield name. They paid for the expectation, communicated in every brochure, every open day, every carefully worded email from administration, that their children would be shaped here, guided, prepared, that the people in charge understood what was best. Principal Douglas Hargrove had run Crestfield for 14 years. He was, by nearly every surface measure, exactly what an institution like that wanted at its center. He dressed well. He spoke with precision. He had a memory for student names that parents found impressive and students found slightly unsettling. He gave welcoming speeches at the start of each school year that managed to be both warm and commanding, the kind of speeches that made parents feel reassured and students feel watched. He was not a cruel man in the obvious sense. He didn't shout. He didn't demean people in public spaces. His cruelty was the more practiced kind, deployed privately, within the architecture of authority, in ways that were easy to dismiss and difficult to prove. He had been managing the school for so long that the boundary between his personal preferences and institutional policy had blurred almost entirely. The teachers knew which students Hargrove liked and which he didn't. Those distinctions weren't always spelled out, but they were communicated in the way he responded to reports about certain students, in the way he handled disciplinary matters, in the way certain complaints moved quickly through the system and others stalled. Isaiah Torres was 16 when he enrolled at Crestfield on a merit scholarship. He had tested into the school from a public middle school across the city. One of 11 scholarship students admitted that year, part of a program Crestfield ran to demonstrate, in its annual reports and donor communications, a commitment to access and inclusion. Isaiah was quiet in the way that academically focused, socially cautious teenagers often are, watchful, precise, not easily read. He was an exceptional student of mathematics and a decent writer. He had a small group of friends and a mother named Carmen who worked as a hospital administrator and had raised him largely alone after his father's death when Isaiah was 9. She was not a woman who came from money. She was a woman who came from discipline and expectation, and she had raised her son in the same tradition. Isaiah's first year at Crestfield passed without significant incident. His second year began a process that would take more than a year to fully understand. It started with an accusation. In the spring of his junior year, Isaiah was accused by another student of academic dishonesty, specifically of having accessed a draft version of an examination question set before the exam. The accusing student, whose family had donated significantly to the school's capital campaign, provided an account that was vague on specifics but confident in delivery. Hargrove convened a disciplinary review within days. The review concluded that there was insufficient evidence to substantiate the allegation. Isaiah was cleared. The process should have ended there. It did not. Over the months that followed, Isaiah found himself subject to a pattern of administrative attention that was difficult to name precisely because each individual instance could be explained away. His scholarship eligibility was flagged for review based on a policy that Hargrove had revised shortly after the disciplinary case concluded. His access to a tutoring program was restricted, pending what was described as a resource allocation decision. He was removed from a leadership committee he had been appointed to by a teacher, replaced by a student whose family sat on the school's board of trustees. None of these things happened loudly. None of them came with written explanation that acknowledged any connection to the prior accusation. They arrived through the normal channels of institutional life: memos, emails, policy updates, in the language of administration rather than the language of punishment. Carmen Torres noticed. She was not someone who looked for conflict. She had spent her career navigating institutional systems, and she understood the difference between the friction of bureaucracy and the friction of intent. What she was watching happen to her son felt different from ordinary bureaucracy. It felt directed. She requested meetings with Hargrove. He was consistently courteous and consistently unhelpful, describing each decision as a separate matter with its own justification. She requested documentation. Some was provided, some was not. She asked in writing whether Isaiah's disciplinary history was influencing any current administrative decisions regarding his status at the school. Hargrove responded, also in writing, that the cleared disciplinary matter had no bearing on any current decisions and that Isaiah remained in good standing. That letter would become important later. Carmen retained an education rights attorney named Sylvia Park. Park was methodical and experienced in the specific mechanics of how schools, particularly private schools with significant resources, managed adverse relationships with students they had decided to remove from good standing. She reviewed everything Carmen had documented. She sent a formal letter to Crestfield's administration, identifying concerns about the pattern of decisions affecting Isaiah and requesting full disclosure of any communications or internal deliberations that related to his status since the disciplinary review. Hargrove's response, through the school's legal counsel, was to decline the records request on the basis that the institution's internal deliberations were protected administrative communications. He also, and this would later become one of the more remarkable details in the entire case, sent a separate letter directly to Isaiah, not to Carmen, not to Sylvia Park, to Isaiah. The letter, written on Crestfield letterhead and signed by Hargrove, informed Isaiah that his continued enrollment at the school was contingent on his demonstration of the values of the Crestfield community, and that the school had become aware of external proceedings that raised concerns about his alignment with those values. It told him, in careful but unmistakable language, that if the current legal inquiries continued, the school would be required to reassess his enrollment status. He was 17 years old. The letter was, in plain terms, a threat, written by a principal to a minor student, warning him that the consequence of his mother and her attorney pursuing legitimate legal inquiries would be his removal from school. It was also sent directly to the student, bypassing his legal guardian and her attorney entirely, in a move that was either strategically calculated or profoundly careless, and neither possibility was comforting. Sylvia Park filed suit. The grounds included retaliation against a student for protected legal activity, failure to produce records in response to a valid educational rights request, and interference with the parent-child relationship by sending communications to a minor that were designed to discourage legal proceedings. The case moved through preliminary stages over several months. During that time, Isaiah continued attending Crestfield, partly because removing him would only strengthen the retaliation claim, partly because Carmen and Sylvia Park believed the process of accountability needed to be completed in full. He continued doing his work. He continued getting his grades. He did this while knowing that the man who ran his school had written him a letter designed to frighten him into silence. He was not silent. In the pre-trial depositions, Hargrove was represented by the school's legal team, a well-resourced group from a firm that had represented the institution in various matters over the years. His demeanor in deposition transcripts was consistent with how people described him in person. Precise, composed, strategic in the management of what he acknowledged and what he characterized differently. He denied that the letter to Isaiah was intended as a threat. He described it as a routine communication about community standards. He denied that the pattern of administrative decisions following the disciplinary review had any connection to that review. He attributed each decision to independent policy considerations. When asked about the decision to send the letter directly to Isaiah rather than to his guardian or her attorney, he said that as principal, he had a direct relationship with enrolled students, and that this was a normal part of that relationship. The judge presiding over the case was the Honorable Ruth Anand. She had been on the bench for 19 years and had spent a significant portion of her earlier career in civil rights litigation. She was known for reading everything in a case, not just the briefs and exhibits, but the texture of behavior the documents revealed. She was also known for having very little patience for the specific kind of institutional doublespeak that dresses up deliberate action in the language of neutral policy. She had read the letter Hargrove sent to Isaiah. She had read it carefully, and when the hearing arrived where Hargrove appeared in person for the first time, a procedural hearing that would determine the scope of records to be produced ahead of trial, she was already in possession of a clear picture of what had happened. Hargrove arrived at the courthouse in the manner of a man attending a professional obligation. He was suited, composed, accompanied by his legal team. He had the practiced equanimity of someone who had managed difficult situations before and expected to manage this one. He had sat in rooms like this in his professional capacity, not as a respondent, but as the authority figure, and he carried that posture with him into the room. The hearing began procedurally enough. Arguments about the scope of the record's request, discussion of what the school considered protected deliberation versus what the law required to be disclosed. Hargrove's counsel made articulate arguments. Sylvia Park responded with equal precision. Then Judge Annan turned her attention directly to Hargrove. She had questions, not abstract questions about policy. Specific questions about specific documents, about specific decisions that she had reviewed in the materials before her. She asked him to explain the timeline of the scholarship review that had begun shortly after the disciplinary case was cleared. He explained it in the language of administrative policy. She asked him to identify any documentation that predated the disciplinary case that indicated a scholarship review was already planned or scheduled. He acknowledged that no such documentation existed. She asked him about the letter to Isaiah. His attorney began to interject. Judge Anand indicated, without particular emphasis, but with complete clarity, that she was directing the question to him. He repeated the characterization he had given in deposition. A routine communication, a matter of community standards. She read the letter's relevant passage aloud, not to humiliate, not to perform. She read it the way judges read documents when they want there to be no ambiguity about what the words actually say. Then she asked him directly whether he understood that sending communications to a minor that were designed to discourage legal proceedings, regardless of how those communications were characterized, was not a protected administrative action. He said that had not been his intent. She said that the court was less interested in stated intent than in documented effect, and that the effect of the letter was visible in the language of the letter itself. Then she said something that no one in that room had anticipated. She said that she was expanding the scope of the record's production order, that it would now include all internal communications referencing Isaiah Torres from the date of his enrollment through the present day, and all communications referencing the disciplinary review, the scholarship review, and the decisions regarding his program access and committee participation. She said that any claim of protected deliberation on these matters would be reviewed by the court directly, and that she would be reading every document herself. She also said that she was placing on the record a preliminary finding, not a final ruling, but a preliminary finding, that the letter sent to Isaiah Torres by Principal Hargrove appeared on its face to constitute an improper attempt to discourage a minor from benefiting from ongoing legal proceedings initiated on his behalf. She noted that this finding would inform the court's approach to the remainder of the case. Hargrove's composure did not collapse visibly, but people in that room who had watched him arrive with the ease of a man certain he was in a manageable situation described a different quality to his stillness by the time she finished speaking. The kind of stillness that isn't calm. That's something closer to recalibration under pressure. What followed the hearing took several more months to resolve. The record's production, expanded as ordered, yielded a set of internal communications that told a story the external record had not. Emails between Hargrove and a senior administrator referenced the need to manage the Torres situation within days of the disciplinary case being cleared. A message to the scholarship coordinator noted that we should revisit the eligibility parameters for certain categories, sent the same week. There was no message that said, in plain words, that Isaiah Torres was being pushed out for pursuing a cleared allegation. But the pattern, documented, time-stamped, and placed in sequence, was far more difficult to explain away than any individual action had been. When the full evidence package was assembled and the case reached its final hearing, the school's legal posture had shifted noticeably. The confident, expansive arguments of earlier proceedings had contracted. The language was more careful. The acknowledgments were more measured. Sylvia Park argued clearly and completely. She laid out the timeline, the internal communications, the letter, the pattern of decisions. She connected each piece to the specific legal claims she had filed. She did not overstate. She did not perform. She presented the case the way someone presents a thing they know is already true and simply needs to be seen clearly by the right person. Judge Anand had been that right person since the beginning. Her ruling found in favor of Isaiah Torres on the core claims, retaliation, and improper interference with protected legal activity. The school was ordered to pay damages and legal costs, to restore Isaiah's scholarship eligibility to its original terms, and to submit to an independent review of its student disciplinary and administrative procedures. Hargrove was individually cited in the ruling for the conduct surrounding the letter, with the court's findings referred to the state's Educational Licensing Board for review of his fitness to hold the position of principal. Carmen Torres, who had watched every hearing, who had documented every letter and saved every email, who had paid Sylvia Park's retainer by cutting back on everything that could be cut, sat in that courtroom and did not make a sound when the ruling was read. Her son was sitting beside her. He was 18 by then. He had been accepted to 3 universities and was finishing his final months at Crestfield. After the hearing, outside the courthouse, she was asked by a local reporter whether she had anything to say. She said that she had raised her son to trust the process, and she said that the process had, in this case, worked the way it was supposed to. She said she hoped other parents would know that it was possible to push back, that the size and reputation of an institution did not make it right. Isaiah didn't give a statement. He nodded when his mother spoke. He was looking somewhere else, not distracted, just somewhere past the courthouse, somewhere forward. The way someone looks when they're already in the next chapter. There is something that needs to be said plainly about what Douglas Hargrove did and why it matters beyond this single case. He didn't threaten Isaiah in a parking lot. He didn't say anything crude or loud. He wrote a letter on official letterhead in the careful language of institutional authority, to a 17-year-old boy, designed to make that boy believe that seeking justice would cost him his school, his scholarship, and his future. That is a specific kind of cruelty. It is the kind that understands exactly how power works and exploits that understanding against someone with far less of it. It uses the machinery of the institution, the letterhead, the official signature, the language of policy and community values, as a weapon aimed at a minor who had done nothing wrong except exist in a space where someone powerful had decided to make his presence difficult. What made it worse was that it very nearly worked. Isaiah Torres did not become visibly frightened in the way that the letter was probably designed to produce, but the weight of it, the awareness that the person in charge of his educational environment was communicating that his mother's pursuit of accountability was threatening his place in that environment, was real. He felt it. Carmen felt it. The letter was written to be felt, and this is why authority in educational settings requires oversight that is not provided by the institution itself. Schools, particularly well-resourced private institutions, have enormous power over the students within them. That power is appropriate when it is exercised in the genuine interest of students. When it is turned against students, when it is used to punish, intimidate, or silence, it becomes something very different, something that a court, and only a court, can properly assess. Judge Anand understood that. She had recognized the letter for what it was the first time she read it. She had asked her questions not to perform authority, but to establish facts in a record that would support a ruling the evidence warranted. That is what courts are for. Not for the powerful to manage outcomes. For the record to be heard completely and the truth to be addressed directly. Isaiah Torres went to university. He studied applied mathematics. He has not spoken publicly about the case since the ruling. He doesn't owe anyone that story. He lived it. He carried it through his final year of school with a composure that his mother's raising had built in him, and then he moved forward. Carmen Torres continues to tell people, parents she meets, people who ask, that the documentation matters, that the emails matter, that the letters you save matter, that the moment something feels wrong, you write it down, you date it, and you keep it. Because institutions count on people not being organized enough to reconstruct the pattern. Because the pattern is exactly what they need to not be seen. She was organized enough. The pattern was seen. There are schools, right now, in cities and towns and districts across the country, where students like Isaiah Torres are sitting across from administrators who have decided that their presence is inconvenient, where the machinery of institutional authority is being used, quietly and carefully, to make young people feel small, feel frightened, feel like the cost of pushing back is too high. Most of those students don't have a Sylvia Park. Most don't have a Carmen Torres. Most don't end up in front of a Judge Anand. That's not a reason to stop. That's a reason to make it more possible. The work of accountability is not glamorous. It does not always resolve in a single hearing. It involves reading documents and sending emails and sitting in courtrooms and waiting and preparing and returning again and again to the record. It is slow and expensive and exhausting, and it asks a great deal of people who are already carrying the weight of the wrong that was done to them. But it is real, and sometimes, not always, but sometimes, it works exactly the way it should. A principal wrote a threatening letter to a 17-year-old and believed that the authority of his position and the weight of his institution would protect him from the consequence of doing so. A judge read the letter. A mother kept the records. A lawyer did the work. And in a courtroom, the truth was placed in front of someone who understood what she was looking at and was not afraid to say so. That is not a small thing. In a world where power routinely writes its own rules, the moment when someone with equal or greater authority looks at the record and says, "No, this is what actually happened, and this is what it means," that moment is everything. Isaiah Torres knew it. even if he didn't say it out loud. He knew it in the way he sat beside his mother and looked past the courthouse into whatever came next. And what came next was the rest of his life, built on the fact that, when it mattered, the truth had not been buried. The record had survived, and a judge had stepped in. That's what justice looks like when it works. Not perfect, not fast, but real. And in that courtroom, on that day, entirely, completely, undeniably real.